Chris Hayes. Tonight we have some late-breaking developments regarding a trove of White House documents that the ex-president has been trying to block the release of. In a huge rebuke to Donald Trump, tonight the Supreme Court has rejected Trump's attempt to block the committee investigating the January 6th insurrection from accessing those documents from Trump's time in the White House. This evening, the committee was set to receive a tiny handful of documents, just 4 pages. But in light of this decision, just happened about 90 minutes ago, the committee will now have access to all of the hundreds of pages of documents it requested. That's not the only big news tonight. We also have a new round of subpoenas from the January 6th committee, which we will be getting to in just a bit. But to put the Supreme Court ruling in context, Trump, of course, has been fighting the release of these documents since last October, when he claimed they were protected by executive privilege, even as the current president, Joe Biden, the executive of executive privilege, said they were not covered by executive privilege. A number of appeals courts emphatically rejected Trump's argument. And now the Supreme Court, with, of course, a 6-3 conservative majority, has as well. Justice Clarence Thomas was the only announced dissenting voice in the decision. Trump now has nowhere left to appeal. The case is closed. The documents are going to get turned over. The ruling's also notable in the light of the fact that a number of close Trump allies, including former White House Chief of Staff Mark Meadows, have been relying on similar claims of executive privilege to defy their subpoenas to appear before the committee and offer testimony. It's not clear at this time how this ruling will affect those arguments, if at all, but we can imagine they will be resolved pretty soon. Danya Perry is a former New York State Deputy Attorney General and New York State federal prosecutor. She and other lawyers at her firm filed an amicus brief on behalf of state and local officials asking the Supreme Court to do what they just did, reject Trump's attempt to block the National Archives from releasing records about January 6th. And Danya Perry joins me now. Danya, first, let's just start with what the court is holding here and what it means on the ground.
Sure. So the court summarily denied Trump's appeal. So they are refusing to stand in the way of the release, the immediate release of these January 6th records from the National Archives to the Select Committee. If there's someone working late in the bowels of the archives, they may already be in the hands of the Select Committee. So that is a resounding loss for President Trump, former President Trump, and the arguments he made. It's a little cabined. The court made clear that they were not relying on one of the primary arguments that had been made in the courts below. That is that President Biden's willingness to waive any claim of executive privilege, that is the reason why Trump lost. So it various proposed witnesses before the committee. But for right now and for President Trump, it's a terrible defeat.
Right. So we know that he wanted to stop a bunch of these documents. We think they include binders of talking points about the 2020 election. Are some of them we're led to believe 700 pages of the 1,600 requested. So just to zero in on what you said, there's sort of 2 things happening. One is the question of are these documents subject to executive privilege? And the other is the principle of, is it possible for an ex-president to assert executive privilege in the abstract? And what you're saying is the court doesn't reach that second question, essentially, here, about whether they can or cannot. That remains to be seen, perhaps in further litigation.
That's exactly right. Justice Kavanaugh would have he concurred, and he would have said, he would have ruled that, in fact, a former president does have quite a bit to say about the nature of the privilege. But the court, in that 8-1 ruling, decided that it didn't have to decide. In other words, it refrained from making any ruling, said that it didn't have to, because as the Court of Appeals said below, on any standard, Trump would lose. And that was because he did not make a particularized showing at all. As he often does, he just claims a blanket and absolute privilege. That has not worked for him in the past, and it didn't work for him here. He made no showing with respect to any single document as to why the privilege would fly, and that did not fly with the Court of Appeals and ultimately with the Supreme Court.
Yeah, the court's ruling saying because of the Court of Appeals, which is, of course, they're upholding here, because the Court of Appeals concluded President Trump's claims would have failed even if he were the incumbent. His status as a former president necessarily made no difference to the court's decision, meaning they don't read that. I mean, I guess just to take a step back here, the committee gets the documents, Trump loses, but we should also note, like, this wasn't a close call legally by any stretch of the imagination, right? I mean, it would have been a truly shocking and lawless action had the court found another way.
100%. What he was trying to do, which has worked for him so well in the past, is gum up the system, let this case, take its time going up and down the court system.
Right.
That has worked successfully for him before. And I am sure his gambit here was to have the injunction in place pending certiorari, pending a full review on the merits. And I'm sure his hope was that with the 2022 elections, that the focus would change. And so the real issue here, and this is something that we focused on in our amicus brief to the court, is the urgency, the immediacy, the continuing threat, and that this had to be decided quickly. And they did. This was, I think, 3 months to the day, maybe 3 months and a day from the time that Trump filed his initial petition to the date that the Supreme Court decided. It's remarkable. So we've seen many times before this doesn't always go so smoothly and so quickly. Happily, it did in this case, and the Select Committee can move on to do their important work.
Yeah, I just want to reemphasize that point because I made a snarky comment to Congressman Schiff, I think it was last night, noting how expeditiously they moved to block the vaccine or testing mandate under OSHA that the Biden administration tried to put in, showing that when motivated, they can move fairly quickly. To their credit, this was lightning pace by the Supreme Court standards, essentially, in what they came to today, and does mean that the delay tactic doesn't work because right now those documents are probably being transmitted, and that's kind of the end of that, right?
That's the end of that. As you say, there will be other fights. They're coming up quickly. There's been a new flurry of activity of subpoenas being issued, a number of witnesses who have to come up. So they'll have to decide how this ruling affects them.